Because the work is given to us.
What follows?
Yes, right. SSC has destroyed the original OMR sheet ostensibly with scanned mirror image thereof being preserved in its server. Now, will it destroy in accordance with rules? Will it be said? Your Lordship can consider that. That's all. CJI did not find any scanned mirror image in the server of SSC. That is true. Because we relied on the person and the NICE gave us the data at all times. Even today, NICE is giving the data. Whether it is from an ex-employee, whether it is covered by a 65B certificate, all those are questions. But the data which the CJI is using, which I am using, all that data has actually come from NICE. Now, C6, OMR sheets have been destroyed without scan. So, therefore, there is no...
Now, when you destroy the OMR sheet, it was the Staff Selection Commission's duty to ensure that the mirror images are preserved in the server.
So,
now there is no mirror image in the server at all. So your case is that, look, I was duty bound to destroy it after a certain stipulated period. But equally, it is your responsibility as the SSC to keep the images, the scanned images in the server.
Fair enough, Milord. The question that
why they not being preserved in the server?
But it is being preserved.
Where?
In NICE.
No, but CBI doesn't find it in your server.
No. The digital information is to be preserved.
But in your server.
Now it is not being found in my server, but it is found where it was taken.
But it's worse because NICE at the highest is only an outsourcing agency. Imagine your entire data is now found in the server of an outsourcing agency.
So now, Milord,
can there be a greater breach of security protocols?
Milord, would this be enough, Milord, to set aside, Milord, the employment of 25,000 people is the question. Now, these three paragraphs are actually 1 point itself. 1 point.
It is then of the whole process.
So, if CJI is proceeding on that basis, CJI is taking that data only to prosecute.
Now, if these were destroyed, Ticket 7, SSC had provided scanned OMR sheets to RTI applicants in the year 2018 till 2018.
From NICE.
So that means you knew that the entire data was maintained with NICE.
Of course I did. Not data scan. It was not maintained with data scan. It was maintained with NICE.
What was maintained with NICE?
The data. The entire data. Digital OMR data.
How can that means that you are the statutory body? You allow the entire scanned data to be maintained by an outsourcing agency. It is only a labor provider to do the scanning.
But today, that very data is being used in a prosecution. So,
but today we are looking at your breach of your statutory.
Your Lordship will look at my breach. I am only going to show your Lordship what is the actual breach.
Say that look nice, took it away. You are responsible for maintaining it. It is people's data. It is people's data.
Please don't misunderstand. I am not blaming NICE. I am not blaming NICE. I am even accepting that without a 65B or not.
Now see what follows. I said that I declared it.
Just add one thing here, Milord. If I may just add one thing, Milord. This very data, the very data that is being used by this court in this judgment, and the data which will be used in the prosecution by CJI has completed its investigation. It has said so to the court that we have completed the investigation. Charge sheets have been filed. Now that is going on. Now the question is, Lord, this very data is going to be looked at for both the purposes of this judgment and that. So, Lord, the authenticity of this data is not going to be under challenge.
Now C7.
Yes, now 7. SSC has provided scanned OMR sheet to RTI applicants claiming that such was from the database, although CJI did not find.
So, you have responded to RTI queries saying this is from my database.
No, I don't know whether it said mine.
Yes.
Just the database.
From your database. And now it's come to light that this is not in your database at all. That means what you were saying to RTI applicants that look, this is in my database. So that is incorrect. Look at the Staff Selection Commission's modalities of conducting it, Mr.
Well, it may be, my lord. It may be, but the same very data is being relied upon. Today, this judgment would go if you take away that data. It will have to be set aside. Because my lord, in one chapter,
There is no data at all.
suppose there isn't, my lord. Suppose there isn't. Then what will happen to this judgment?
Then the appointments have to go. Because either you have the data.
Yes.
If you don't have any data, we understand that OMR sheets in the physical form, you can't maintain them in eternity.
Yes.
But then two things. You are duty bound to maintain the underlying documents in a digitized form. Because now today with digitization, it obviates the requirement of all that storage and everything. Now you say that, look, I don't even have you provide RTI responses. Saying this is from my database. Now it's obvious that there is no data in your database.
All right.
That
All I'm saying is, that I am
NICE is
saying
only agency. NICE appoints data fintech.
No, Milord.
You are unaware of the fact that your service provider has further subcontracted the service to somebody else.
Milord,
Surely
your
you
lordship may hold
have
us.
to keep supervisory control.
Very well, my lord. I am not Milord on that. I am saying that the very same data which your lordship Milord are doubting is the basis for the CBI prosecution in this judgment. So if your lordship Milord are not to look into that data, my lord, then this whole judgment has to change. It may still lead to Milord investigation, but it cannot be Milord what is happening now.
Now, appointments higher than the declared vacancies have been given in respect of all four categories.
Appointments higher than the declared vacancy have been given in respect of all four categories.
Appointments given to persons who are not even in the panel.
Yes.
Appointments given to persons who submitted blank OMR sheets.
Yes.
Appointments given to persons after expiry of the panel.
Yes.
Persons placed lower in rank had been given appointment in preference to persons placed higher in rank in the merit list.
Yes.
Merit lists containing marks obtained by respective candidates have never been published.
Yes.
Counselling had been held subsequent to the expiry of the panel.
Yes.
Total beneficiaries of the illegalities are yet to be identified and rendered improbable given the stand of SSC board in the state. SSC had applied for permission to create supernumerary posts to accommodate the illegal appointees, and recruitment rules governing the four categories had never been adhered to either in letter or...
No, that last one is a conclusion.
That's
Now,
it.
I have made a chart. We have exact data as to which category which appointment falls into. And we are not defending. We are not defending appointments which have jumped the list. We are not defending those appointments which have come outside the panel. We are not. We are saying, my lord, that the 16,000 of this 24,000, 19,000 of this 24,000 are not tarnished by any of these clauses. And it is very easy to demonstrate it. It is very easy to demonstrate. We have prepared the chart. The chart will show, my lord, that out of this 24,000, 19,000 were appointed from existing merit lists in accordance with the merit list, within vacancy, within time, everything. And my lord, we were the ones who came forward and gave that data to the court, saying that these are not certain my lord, appointments cannot be justified.
So according to 19,000 are within the merit list.
At least, my lord, that is our rough my lord, estimate at this point of time. And we told the court that we are prepared to do this exercise all over again. Please see one paragraph only of the judgment. My lord, page 99. I think your lordships are looking at another SLP, but I am on my lord paragraph 33. My pagination, because I am in 10.1, may not match, my lord. But look at 33. In fact, my lord, I'm sorry. Page 124 PDF. ফাইনালি পৌঁছতে পারবো। 33, which is recorded in the judgment.
How do you displace these findings, Mr. Gupta?
I am not dismissing all those 4 categories that I have segregated now.
But look at it's a systemic fraud.
Just look at the directions, then is this fair? Look at the directions now.
And ultimately, Mr. Gupta, what happens is this.
Yes.
Today, public jobs are so scarce and so valued that if the faith of the community in public employment goes, then nothing remains. Because today, you know, public jobs and public employment is extremely valued. This is also social mobility for people coming in from the lower strata. People only aspire that, all right, my daughter and my son will get a government job. If this is the way, I mean, we are virtually purloining public employment. What remains in the system?
But your lordships have said,
how do you displace these findings?
your lordships have said so in several judgments that if it is possible to segregate, we will not exercise the panel. I'll just show you lordships just 2 minutes. One is your own judgment.
Where I think Madhu Diviner appears.
Yes. And I'll show you lordship one other paragraph from another judgment of the same year, 2021, which says that even if...
Interestingly, that was the case where the entire process was set aside.
Yes, correct. But here, your lordships have also had occasion to say that even if there is a small possibility that it is possible to segregate, we will explore that possibility. Because on the one hand, what your lordship is saying is right, that people will have an expectation of public employment. On the other hand, Lord, these very persons will be on the street.
But you have nothing to show that this is the data which I have maintained.
Lord, I'm sorry, my Lord, if this data has to be...
What do you have within your system? Any traceable record to show that this is the data I have maintained?
Lord, the prior chairman of this organization is being prosecuted on the basis of that data. Surely, Lord, if your lordship were to cast doubt on that data, then no criminal prosecution.
Very important point, Millard. This segregation has to be done inevitably even under these directions. Just look at direction number 4. Unfair to say give back the money which you earned by teaching. But you see 4. Persons who have been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments, must return remuneration with interest. So only 3 categories have to demand it, give it back, refund. So the segregation has to be done. And upon segregation, there will be a large group of people who are not required to give up the fund, the payment. Now they will be faced with the situation that they have lost a job, but they are not held responsible.
The 7th direction, further investigation by CJI in respect of all the 4 cases, meaning the 4 categories. On 9th of January 2024, a comprehensive report was given by CJI saying that they have completed investigation. And final charge sheet has been filed. Now, by what process can the report say? You reopen that investigation now? That statement by the CJI is contained in 9/1/2024, page 743 PDF of item 10.1. Found out various categories. As I told you, Lordship, the categories include those who have been recommended as per merit list and some who have been appointed pursuant to orders of court. So these 2 categories, Lord, should not be, subjected to this cancellation is our submission.
Yes.
Secondly, my Lord, as far as the period of the merit list, validity of the merit list, my Lord, that we wish to defend. Because, my Lord, there are, in some cases there are rules, in other cases there are executive orders for stated reasons. We wish to defend that beyond the period. and we wish to segregate persons whose OMR data, digital data does not match our server. We do not wish to define persons who were appointed from the waiting list, not in accordance with rank. Rank jumping is the phrase used here. Summarize. Appointment. And there are some people who have been appointed without our recommendation at all. Those also, we are not defending. I'll just give your lordship the judgments. Your lordships are aware. 2021, 4 SSC 631 is your lordship's judgment. 4 SSC page 631, paragraphs 35 and 55. And 2021, 7 SSC 613, 7 SSC 613, paragraph 73. But if it is even possible, then one should prefer to segregate rather than cancel the whole. So this is my submission.
Yes, Mr.
SSC.